I hope everyone's having a great day so far. Again, good morning. My name is Rosalind Sagara, and I'm the Senior Neighborhood Outreach Manager with the Los Angeles Conservancy. And I'm very excited to welcome you to our Legacy Business Toolkit webinar series. Today's webinar is on the topic of commercial anti-displacement. And as we get started, I wanted to set the stage for today's presentations. If I can have Nissa. Oh, so first we're gonna just ask you to please, if you may, stay on mute during the presentations, and feel free to submit your questions in the Q&A, and we will be, after the speakers share their presentations, we'll be having a Q&A and questions. So you're welcome to pop those in the chat or the Q&A. We are recording this webinar, and it will be available for you to take a look at again at the City of Los Angeles's Legacy Business website. The link is provided there. So as I mentioned, I wanted to just set the stage for today's presentations. In 2024, as part of the development of the Legacy Business Toolkit, the Conservancy surveyed Los Angeles area legacy businesses and found that 80% did not own their properties where their businesses were located. Of these respondents, about a third of them had month-to-month leases or no lease agreements at all. Next slide. We also found that 43% of the respondents said they were currently facing or concerned about property redevelopment, eviction, or severe rent increases. Those that responded yes cited building repairs, crime and homelessness, rent increases, and neighborhood change as concerns. And of those, small percentage who said either yes or no, they did cite rent increases, continued impacts to COVID-19, gentrification, and impacts from nearby construction projects as some of their identified concerns. So these findings prompted us to develop the Understanding Commercial Anti-Displacement Guide as part of the Legacy Business Toolkit, which brings us to today. This webinar is the first of two that we'll host this week to delve into important tools and strategies that have been created and used to combat commercial displacement in Los Angeles. And before we get to our speakers, I just wanted to invite Nissa Buck from the City of Los Angeles to share a bit more about the Legacy Business Program.
Thanks, Rosalind. Hello. So I'm just going to go pretty quickly through the slides so we could get to the meat of the webinar. But basically, the Legacy Business Program was developed to help longstanding businesses celebrate them and also provide technical assistance so that they can stay around for much longer. The definition of a legacy business as set by council was a business that's been around for at least 20 years or more within the same community, and they have to meet 3 of the following 4 criteria: contribute significantly to their community, sustain or cultivate traditional traditions or practices, not franchise or affiliate with national chains, or provides vital goods and services in a language manner that's culturally accessible to their community. This is our current status with our legacy businesses. We're at 733 and always happy to bring on more. And part of the program will be focusing on promotional activities such as social media, and we'll send little toolkits that has like stickers. And we also have an exclusive grant, which we'll be launching later this year for round 3. And the amount is based off of how many employees you have. And then the last, or another part of it, is the toolkit, which is what this webinar is part of. And then that's our website, so you can come visit it at a later date. And then Ramya and Ritu will take over.
Yeah, hi everyone. Good morning. Thank you for being here. My name is Ramia Sinha. I am a legal fellow and attorney on the small business development team at Betzedek Legal Services. My work focuses on serving small business owners, but specifically legacy businesses. That is the focus of my fellowship. And I provide direct representation and also focus on policy work and providing community presentations such as this one. So, yeah, it's a little bit about me. I'll let Ritu go ahead and introduce yourself.
Hi, everyone. Good morning. Thanks for being here today. My name is Ritu Mahajan. I'm the directing attorney of Public Counsel's Community Development Project. We provide free legal assistance to small business owners as well as nonprofits that are serving low-income communities.
Okay, so with Betzedek and Public Counsel, we both offer a wide range of services. So one is webinars and presentations, such as this one, direct client representation to small business owners who meet our specific eligibility requirements, can be connected to an attorney who will directly represent them on a wide range of legal matters. And we also offer small business academies that are kind of like legal boot camps for small business owners. Okay, so for direct client representation, small business owners who meet our eligibility requirements can be connected with an attorney to help them on a wide range of issues, such as drafting and reviewing contracts, choice of entity, drafting and reviewing leases, also negotiating with landlords as well, intellectual property matters, employment law, tax issues, and etc. So there's a lot of different issues that we can help with. So yeah. Okay, so just want to give a quick disclaimer. So the following information is intended to assist in spotting legal issues that are relevant to small businesses in the state of California. There are many factors to be considered in determining which actions and decisions would be most appropriate to any specific situation. So this presentation only discusses some of the more like important factors. It's not intended to substitute for legal advice. And the attorneys presenting today are not providing legal advice or entering into an attorney-client relationship with any attendee. We're here to provide information only, and nothing said during this presentation is confidential. You should decide which course of action is best for you after discussing it thoroughly with an attorney. Okay, so the topics that we're gonna cover today, we're gonna go over just commercial leasing overview very briefly, key terms to a lease also pretty briefly, and then we'll talk about new legislation called SB 1103 and really get into that. So, yeah, with that, I'll pass it to Ritu.
Thank you. Okay, so first, we're going to be talking about just an overview of commercial leases. Commercial leases are for businesses, as opposed to residential leases, which are for homes. I know some folks operate businesses out of their home, and so, in that case, you would be using a residential lease. But if you're using a commercial space for your small business, then you'll be using a commercial lease. Um, it's always best if your lease is in writing, and it's signed by both you, the tenant, and landlord. Um, but there's plenty of people that we serve who never had a written lease or are operating based on an oral agreement, which is also valid, but it's harder, right? Because if things aren't in writing, it's harder to enforce your rights under the lease. Um, the law really does treat commercial and residential leases very differently, and there are different protections for residential versus commercial tenants, and so it's an important distinction. Next slide, please. So in some cases, if you're about to lease a commercial space and you find, a spot that you like, you may have an opportunity to enter into what's called like a letter of intent or a term sheet. This is basically not binding, but it's sort of, some of the basic terms that you may have discussed with the landlord or the property manager. The letter of intent or term sheet might discuss, what the rent amount's going to be, whether they're going to give you like any credit on the rent because you're going to make certain improvements to the property. It'll discuss the length of the lease, the condition of the premises, um, any options to renew, what the security deposit will be. This isn't a prerequisite by any means to entering into a lease, but there are times where, you've been in discussions with the landlord or property manager and you want, your discussions to be memorialized in writing, so that when you do get a lease from them to review, hopefully these same terms are in it. Next slide, please. So, when you enter into a lease, there are different sort of ways that the tenant can be described. So a lot of times, our clients are sole proprietors. Some of them have LLCs, for example. So you may request that the lease be in the name of your LLC if you have one, which, I recommend because then if anything goes wrong or, your business owes money to the landlord or the landlord's claiming that you broke the lease, like you didn't follow through on what you're supposed to do, then the landlord's, remedy would be limited to going after your business entity. However, in many instances, the landlord, in addition to having the business entity be the tenant, we see the landlord often requiring the business owner to give a personal guarantee, which means if you do give that personal guarantee, if something goes wrong, the landlord is alleging that you didn't follow through on what you were supposed to do under your lease, that they can go after your business entity, but they can also go after you personally. So we always recommend not signing a personal guarantee if that's an option, but I know it's tough because a lot of times landlords will require one. But yeah, I've seen it both ways. I have seen situations where the landlord will agree just to lease to the business entity and not require a personal guarantee. So it just depends. Okay, so now we're going to talk about key terms in a lease. Next slide, please. So again, every lease has basic terms. It'll have the length of the lease, whether you're going to have an option to renew the lease when it ends. It'll have rules on whether you're allowed to assign the lease to another tenant, whether you're allowed to sublease part of the space to another person. It will discuss, how rent is going to be charged and whether you're also responsible for the landlord's common area maintenance fees. It'll talk about improvements and like repairs and security deposit. Again, it'll mention whether there's going to be a personal guarantee. It'll also talk about what happens if either side, the tenant or the landlord, doesn't do what they're supposed to do under the lease, which is called like a default. And there may be something about holdover, which means if you continue to stay there after your lease is over, holdover is that period after your lease is over, when you continue to be a tenant there. So, when looking at the terms, you have to think about what are the things that are really important to you? What are the things that, you want to negotiate over, and whether you have leverage in this situation. Sometimes tenants do, if the landlord's been looking for a tenant for a long time and they're desperate to, lease to you, you may have more leverage to negotiate terms. Other times you may not have that many options because the landlord, has a lot of people that they could rent to, or is some cases landlords are happy to keep the space vacant. So it's going to depend on each situation. Next slide, please. So one thing to really think about is whether or not your lease allows you to assign it to somebody else or sublease. This is important because we've had a lot of clients who, are struggling as small business owners in this economic climate. And sometimes they do want to consider, subleasing part of the space to someone else so they can make income that way and keep their business afloat and, keep paying the total rent on time. And some tenants decide to sell their business and they want to be able to assign their lease to whoever they sell it to. So when you're entering into a lease, you should look for this kind of clause, you should see, does my lease give me the right to assign or sublet? Um, if so, like under what conditions? And it's important that you have these kind of rights in your lease, because just in case if something goes south and you need to think of other options. Next slide, please. Um, as I mentioned earlier, try not to give a personal guarantee on the lease, but if you're forced to or you have no option, then, there's no choice. And the reason for that is if you do give a personal guarantee or if the lease is signed in your own name, then if something goes wrong, the landlord can go after you personally. Next slide, please. Both landlords and tenants can default under the lease. And like I said, default means like you've done something wrong under the lease. You haven't complied with all your obligations. So it can be like failing to pay rent. It can be failing to, make certain repairs. And the lease will also say what happens in the event of a default. And then before I pass it to Ramya, I'm going to just note that, as we mentioned before, Public Counsel and Betzetic, we provide free legal services to small business owners. A lot of the requests we get are about landlord-tenant disputes and commercial leasing questions. So if you have a specific question related to your lease or your landlord-tenant relationship, please reach out and we can provide you free legal counsel. Thank you.
Awesome. Okay. So now we're going to switch gears and talk about SB 1103, which is a new law. So SB 1103, what is it? Who does it cover? So this legislation applies to what we call qualified commercial tenants, or QCTs, which are micro enterprises, which a micro enterprise is defined as a sole proprietorship, partnership, LLC, or a corporation with 5 or fewer employees, including the owner, who may be part-time, full-time, and generally lacking sufficient access to loans, equity, or other like financial capital. It also applies to restaurants with 10 or fewer employees, nonprofits with 20 or fewer employees. And this legislation, it provides protections on 1, language access, 2, extended notice periods, and 3, standards and transparency with respect to building operating costs. And we'll get into those in a minute. And this law, it applies to leases that are executed or tenancies commenced or renewed on or after January 1st, 2025, month-to-month tenancies, and also applies to leases executed or tenancy commenced before January 1st, 2025 that do not contain a provision regarding building operating costs. Next slide. Okay, so how do you exercise your rights under SB 1103? Well, you QCTs, the qualified commercial tenants, you must notify your landlords of your qualified status in order to receive protections from SB 1103. And so within the previous 12 months, a tenant must have provided the landlord with a written notice that the tenant is a QCT and a self-attestation on the number of employees that you have. And I know there is a really good example of what this like written notice and self-attestation looks like on Public Counsel's website. So definitely take a look at that. And unless the tenancy is week to week, month to month, or for a duration of less than 1 month, the notice and self-attestation must be submitted either prior to or upon execution of the lease agreement, and then annually thereafter. So I do want to note that SB 1103 works prospectively. It does not work retroactively. So meaning that if you are a tenant that, let's say, has a month-to-month tenancy, and you notify your landlord of your QCT status like in May, you can't argue that SB 1103 protection should apply to a rent increase that happens back in January. So it's prospective. It's not retroactive in that way. And a month-to-month tenant can give notice at any time to get the SB 1103 protections going forward from that point on. But I do want to make sure you understand that you must recertify at least every 12 months to maintain these protections. So it's not enough to just, certify once and then think that you're done and that's like sufficient. No, you do need to recertify annually thereafter to make sure you are having those protections. And same thing for like a fixed term or like a long-term lease. A tenant ideally gives SB 1103 notice at the lease like execution. But if you miss that, you can still provide notice during the lease term via the like annual certification requirement or at renewal if your lease like offers a renewal. However, again, protections will only apply like prospectively from when the notice is actually given, so not retroactively. Next slide, please. Okay, so language access. This is one of the first main protections. Um, Basically, this requires a written translation of a commercial lease that's negotiated in Spanish, Chinese, Tagalog, Vietnamese, or Korean, regardless of whether the QCT negotiates the lease through their own interpreter. And a QCT may rescind a contract or cancel the contract that violates this requirement. Next slide, please. Okay. So the second main protections of SB 1103 involves extended notice periods in two main areas. So first, if a landlord increases the rent by more than 10%, they must give at least 90 days notice. Now, if they increase the rent by less than 10%, they must give at least a 30-day notice. And second is if a landlord terminates the tenancy, they must give at least 30-day notice if the QCT has occupied the property for less than 1 year, and a 60-day notice if the QCT has occupied the property for 1 year or more. Next slide. Okay, so building operating costs. So these are often under like operating expenses or CAM fees, but this is a bit more specific than that. So building operating costs are costs that are incurred on behalf of a tenant for the operation, maintenance, or repair of the commercial real property, including but not limited to the maintenance of common areas, utilities that are not separately metered, and taxes or assessments charged to the landlord pursuant to property ownership. And under SB 1103, the landlords must provide QCTs with supporting documentation if they intend to charge these BOCs, building operating costs. And supporting documentation, what that looks like is a dated and itemized quote, contract, receipt, could be an invoice from a licensed contractor or a provider of services. That also includes one, a tabulation showing just how the costs are allocated among tenants, and two, a signed and dated attestation by the landlord that's showing that the documentation and costs are true and correct. Next slide, please. Okay, so a landlord may only charge a QCT with building operating costs if the costs are allocated proportionally by per tenant, so by square footage or another documented method. The costs were incurred within the previous 18 months or are reasonably expected to be incurred within the next 12 months based on just like reasonable estimates. The landlord provides a notice before the lease is executed, stating that the tenant may inspect these like supporting documentation of the building operating costs upon written request. And for within 30 days of a written request, the landlord provides the supporting documentation of the previously incurred or reasonably expected building operating costs. And the costs do not include expenses paid by a tenant directly to a third party. And finally, the costs do not include expenses which insurance, the QCT, or another third party already reimbursed to the landlord. So yeah, those are just the specifics of what those building operating costs look like. Next slide, please. Okay, so remedies. So essentially, if you are a tenant that has provided this sufficient, certification that you are a QCT, but let's say your landlord doesn't do what we discussed, doesn't follow these requirements. So, what are your remedies? Like, what are you allowed to do at that point? So, in the case of the language requirements for the lease, if your landlord does not follow that, you may be able to rescind or cancel your lease. And in the case of the landlord failing to provide enough advance notice of a rent increase or termination of the lease, or if your landlord failed to comply with the building operating costs reporting requirements, their violation of SB 1103 may be used as an affirmative defense to an unlawful detainer or eviction action. So let's say if they, file an unlawful detainer and you receive that, notice, the litigation, you can essentially say as your defense to the eviction, hey, well, I'm a qualified commercial tenant under SB 1103, and my landlord failed to comply with, the advance notice and the building operating costs. So yeah, that's how you're able to bring that up as a remedy. And landlords who violate the BOC terms are also potentially liable to a qualified commercial tenant in a civil action for actual damages in the court's discretion, two, reasonable attorney's fees and costs, and three, possibly punitive damages. So there are a few like remedies for qualified commercial tenants if landlords don't follow this. So yeah, next slide, please. Okay, so I'm not going to go into this too much because that's what Amy will be talking about next. But I just want to say that with this commercial tenants anti-harassment ordinance, your voice as small business owners, legacy businesses that are, commercial tenants, it really, really matters. So when this motion moves forward, small business owners like you can make a huge difference in making this ordinance a reality. So by showing up, maybe making public comment or just supporting in other ways publicly. So we just wanted to essentially kind of give a call to action and say, please show up, please support in any way that you can, because that's going to really make this law a reality. And it's provides a lot of protections for commercial tenants. So it's really important. But yeah, that's all from me. Next slide, please. Yep. Okay, so that is all for Ritu and I. Thank you so much for listening. Like we said, if you have any commercial tenants problems, please, please, please come to Public Counsel, come to Bet Zedek. We're happy to help. Like I mentioned at the start, my work focuses mostly on serving legacy businesses, specifically with commercial leasing issues. So please, please, please reach out if you need some assistance, and we're happy to help. Thank you.
So I can go next. Also, it's good to see some familiar faces. Hi, Rosa, Maria, and Memphis. Can everybody see my screen? Okay, great.
Yes.
Awesome. Thank you. Good to finally be here with everybody. My name is Amy Chong. I'm a Senior Associate of Policy here at Inclusive Action for the City. In this presentation, I will share two parts to what we're trying to share, which is one, the resources that our organization provides to small businesses and entrepreneurs, and two is what we are doing to provide and combat commercial anti-harassment. in the city of LA and also throughout the county. So our organization, we are an economic development organization, also a CDFI, which stands for Community Development Financial Institution. We essentially are on a mission to help underserved communities to thrive in our local economy by access to capital and advancing policy through research and community-driven advocacy. Our vision for our organization is to create a diverse community that has both equitable and sustained access to resources, so that way they have agency over their futures. And this is a beautiful team. In terms of access to capital and business coaching, this is three things that we offer. So first is we offer low interest loans, and I can go into the details of what that entails. And the second is we provide tailored business coaching to small businesses, including legacy businesses that need assistance technically for their business. And lastly, we provide networking and resources to small businesses, so that way small business owners can talk to each other, build community, and essentially just build community with each other, so that way our small business ecosystem can really thrive in the city of LA. So we provide capital, capacity, and community. We are super proud that we are character-based lending, and what that means is that we don't have a minimum a FICO score, or we don't have an ITIN or a social security requirement. Really speaking to the values of the name of our organization, Inclusive Action. We are a very inclusive organization. We don't require bank accounts, and we are really trying to be the organization that meets entrepreneurs with their needs. And this is more of the details of our loan products. As you can see on the left side of the column, there's funding amounts, interest rates, repayment terms, all the way to income requirements. We just ask that people who are applying for our loan products generate less than $3 million in gross sales per year. And all of the other requirements of the loan products, like the SEMIA, is 8% fixed, which is annually, with the repayment term of 12 to 60 months. But our access to capital team will be happy to answer and sit down with you to talk more about the specifics of which loan product might be most suitable for your business. And yeah, this is the general loan products that we have at Inclusive Action. Switching gears a little bit, we are also a part of a coalition of organizations that is listed here in this slide: Inclusive Action, Public Council, Pathetic, Stage, Little Tokyo Service Center, that really advocate for tenant protections for our small businesses. And one way we do that is in the city of LA, we have a commercial anti-displacement policy and legal strategy discussion that we're continuously having with city offices. And one of the things that we did recently is in April 2026, which is last month, a couple weeks ago, we had this motion introduced to the full city council. And we're calling this the LA City Commercial Tenant Anti-Harassment Ordinance. This is essentially a motion that does two things. One of them it instructs the city departments to report back in 90 days with the analysis of how a commercial tenant anti-harassment ordinance could be modeled with some of the work that we have already done in the county. And I'm sorry, I think the text on the slide got cut off. And then the second is instructing the city attorney to participate and report on a legal framework of what a commercial tenant anti-harassment ordinance could look like in the city. This is the very first step of the advocacy process. Because this is an introduction of the motion, there's a couple more next steps that we have to do in order for this win to be successful, which is that first, we need to get the motion to get agendized to the Economic Development and Jobs Committee. And we are not entirely sure when that will be, but we are actively working with the author, which is Isabel Jarado's office, to strategize politically on which offices we should be targeting and discussing with to ensure that the Economic Development and Jobs Committee gets this motion agendized. And then the second thing is once this motion passes in this committee, it will then go through the full city council. And because we don't know when the motion is agendized in the committee, we're not sure exactly when this motion will be agendized in the council. But until then, there's a lot of different small action steps that we have to take in order for us to make sure that this advocacy process is successful. And the way that we do that is 3 different steps. The first step is policy strategy. So coalition partners, like I had mentioned in the slide, is that we are meeting with city council offices to advocate for the passage of this motion. And we do that by convincing the people who sit in the Economic Development Committee, and then also meeting with the full city council team to also advocate for the importance of the commercial tenant anti-harassment ordinance. The second portion is there's a legal strategy to this advocacy process. And we do that by meeting with the city attorney's office to discuss what the ordinance language could look like. Because we have already advocated for this ordinance in the county, we have direct language we can essentially leverage to highlight to the city attorney saying, this has worked before, this is what we can advocate for, this is what we can include in the city. However, there are ways to improve the current LA County ordinance language to improve in the city ordinance language. And then the last thing is outreach strategy. And I'm glad we're having this conversation because everybody here, you guys are all business owners, and we want to activate small business owners to engage in policy and legal strategy conversations, because ultimately the ordinance that we are working on as a coalition is something that will be impacting small business directly. And if there are any policy strategies or things that you feel like needs to be included in the ordinance language to improve the overall well-being of your small business related to anti-harassment, let's talk. And I think we need to definitely try to incorporate some of those best practices, key findings that legacy business like yourselves would like to see in policy like this. And last but not least, we have a lot more ideas, a lot of policy strategies that we are talking about in this coalition. Some of them are including relocation for commercial tenants when they are displaced by redevelopment, a commercial registry on vacant properties, and properties that are up for lease. And then lastly is a commercial landlord business license. And this is just very preliminary ideas at the moment. We don't have any motions that we introduced in the city. We're slowly planting the seeds in different offices to say that these are policies that will work to prevent anti-displacement and also anti-harassment for small businesses. But this is just the first step. So we are really looking forward to kind of activating with you all and learning more about how we can better serve your business through policy and legal strategy. That's it. I think I talked fast, so it was really quick.
Thanks, Amy. Thanks also to Ramya and Ritu for their presentation. So we welcome any questions from the audience. There is one that I see. I'll just read it. It's in the chat. Renee asks, if a landlord plans to sell the property where we rent our business space, are they required to notify the tenant in advance if we've been there for years?
I don't know that there's actually any legal requirement that they notify you. It may depend also on like, are you currently under a lease or are you month-to-month tenant? Technically the new owner, whoever they sell it to, kind of steps into the shoes of the past owner. And so if you did have a lease that was still going, they would have to honor, that new lease. I mean, that not new lease, but they'd have to honor that lease. But I can look into it and get back to you. But I don't know that there's any legal requirement that they give you a notice that the, property is going to be changing hands. Let me double check on that.
maybe like a slightly different question, and I see that, well, I think Renee has asked a follow-up. They're in a lease. The last one was a renewal for 3 years. I guess a slightly different question would be, could tenants be given the first option to purchase their building if the landlord decides to sell?
Yeah, they can be, but I mean, it's good if that's written into the lease, right? So if that's something you are thinking about, in the lease, you not only would want to build in options to renew the lease, if again, that's something you'd be interested in, but also an option to purchase, if the landlord ever puts the property on the market. And then to Renee's other point, I'd want to see the lease to see like what it might say, if anything, about transferring ownership of the property or sale of the property. Um, but like I said, if you're still under the lease, whoever they sell it to does have to honor the lease. I just am not sure whether they would need to give you any kind of notice that they intend to sell it. It may depend on, the terms of the lease itself. So that's why it'd be helpful to see the lease.
Great, thank you. Let me see if there are other questions. Not just yet. I have a question about the new Tenant Protection Act. So I'm curious to know, like, if you're hearing like good things about this new law. Are commercial tenants aware of this new law, and are there any success stories that you can share?
So it's not you mean SB 1103?
Yes.
Yeah. So, some tenants are aware, we try to, both Betsedic and Public Counsel, we try to do trainings, including this one to educate people on this new law. But I know that there's, a lot of people that still haven't heard of it. Um, I know personally we get legal requests from tenants who are saying to me, like, oh, I heard of this law. I want to know, how do I tell my landlord that I qualify? A lot of times it's coming up when people are already given like a 30-day notice that their tenancy is going to be terminated. And so they're using the law to get like that extra 30 days, like 60 days instead of 30, which I know is still not enough time to find a new place, but any time is helpful at that point. So I've seen that come up on a few circumstances where people are like, oh, I got this notice to terminate, but I fall under SB 1103. How can I get the additional time? I've also seen people call us to ask about the protections related to the common area maintenance fees, because their landlords are asking them to pay these, crazy fees, but the landlord's not providing supporting documentation. And so the tenant will ask us like, oh, how do I, tell them I'm a qualified tenant and that I'm required to get this documentation before I pay the fees. So I feel like the word is getting out there, but there's still a lot more that can be done to educate people on this law. But yeah, I don't know if the other panelists have thoughts too on this question.
Yeah, I have nothing else to add. I think that's about what we're seeing as well. A lot of folks may not know about it or may not know how it works in practice. And like Ritu said, maybe want to just, certify themselves when it's too late, or in a time where it's not really timely and it wouldn't really help. So I think the best thing that we can do is make sure that people are aware of this law now, especially before they are getting into a lease or maybe renewing their lease. I think that's just the most important.
One
Thank
last thing
you.
I'll add is I can put in the chat a model lease that we created for a lease that landlords could use that abide by SB 1103. And if you are, as a small business owner, can present or give that model lease to your landlord, that could serve as a way for you to, advocate for your protections and rights when you are discussing that with your landlord.
Thank you. There's another question. how do you see community members who care about legacy businesses and local entrepreneurs supporting this cause and policies? So I think I'm not sure if the cause is the current motion that has been proposed, and maybe any other policies that support legacy and small businesses. How can community members support?
I mean, I think one thing that folks can do is, like as this motion moves through the city committees and then eventually goes to city council, um, council members really need to hear from business owners themselves about how the lack of protections has impacted them, and how, the forces that are putting pressure on them to move out and to close their businesses, and why there's a need for more protections. Um, and, not even just limited to the anti-harassment motion, but beyond that, right? Like we've talked to tenants about a vacancy tax, relocation requirement, that they get money if their landlords, kick them out and they're forced to move. So I think just making your voices heard, being able to talk about what you've been through and why more protections are needed is very helpful, because, the landlords and their lobby does a great job, and they have a lot of resources to kind of talk to folks about saying, like, why these protections are not needed, or why, landlords should be given like the same I guess advantages as tenants, and why the city shouldn't get involved. So like we just need more business owners, I think, to organize and like share their stories, and we're happy to facilitate that. Like when this motion goes through the city departments and there's opportunity to give public comment, it'd be great to get people to show up and give comment, in front of the city council members, and share their experiences, their firsthand experiences with tenant harassment and displacement.
Thank you. This is more of a kind of a consideration request from Toad's Market, asking, can you help us use the money that's collected from small business taxes to purchase our business property, or how can we get that tax money to help small businesses? I'm wondering if maybe Amy, you could speak a little to some of the work that Inclusive Action's doing on purchasing commercial properties.
Yeah. Um, to your direct question, Memphis, it's a great question, and it is truly really unfair what that small businesses are paying taxes to the city, but that money is not being used to serve small businesses. So I'm not entirely sure where the money is going, so I can't speak on that. However, related to business properties, or property that small businesses can acquire. At Inclusive Action, we have a real estate arm where we have already purchased a couple of buildings in the Boyle Heights area to ensure that the speculative market, like real estate developers, big businesses, can't acquire those buildings to eventually kick people out. So we're in the process of, trying to acquire more property, so that way the properties that we acquire could stay in the neighborhood and also be leased to local small businesses and nonprofits. So there's organizations like us and other CDFI organizations that have a real estate strategy arm to really try to prevent further displacement from small businesses, so that way they stay in our local neighborhoods.
Thank you. You can read more about community ownership in the Legacy Business Toolkit, and we could share the link to that as well. And there's more information on Inclusive Action's website also, in terms of how they are helping in this area. I will plug Thursday's webinar. We will have Bill Watanabe from the Little Tokyo Community Impact Fund that will be speaking about their group's effort to purchase commercial buildings and put that in community ownership. Let's see if we have any more questions. I'm not seeing any more right now. I will, oh, I see that NISA has put up the upcoming webinars as part of this series. So we welcome you to check these out. These are free and open to the public, so feel free to share them with anybody that you think would be interested in learning more about these topics. I want to maybe give the speakers a last word. Before we close out.
Yeah, I mean, definitely reach out if you all need any business coaching, small business loan products that could help, sustain your business, expand your business. Yeah, reach out to us whenever. And then in terms of just policy engagement, if you have any initial thoughts about what we had presented regarding SB 1103 or the anti-harassment ordinance motion that we had introduced, I'm all ears, would love to chat with you all and discuss further policy strategies that can really support small businesses in LA. And I can put my email in the chat.
Yes, yes. I also put our BetZedX like online application in the chat, as well as my email. So yeah, please feel free to email me, or probably the easiest way is to just fill out our application and we'll see what we can do for you and how we can help. So yeah.
Anything you wanted to add, Ritu or Nissa?
Just, thank you for being here, everyone. And like we said, we're here to support you. I know it's very difficult with the lack of commercial tenant protections, but, I think that we're building a movement to, hopefully advance more of those in the coming years. And we need all of you. We need to do this together. So yeah, please reach out if you need help.
Yeah, and I'll follow up with an email to everybody with the documents or the presentation as well as all the links that everyone was providing. So you have it in your email as well.
Great. Thanks so much, everyone. We hope to see you at a future webinar. Take care.
Bye. Thank you.
Thank you.
Thank you.